Okay, sir, let's begin. Hello, everyone, and welcome to Law Insider. My name is Prachi Singal, and I am the Associate Editor with the Law Insider. Today, we have with us Mr. Mohit Mathur, Senior Advocate, to share his life experience as an advocate with us. Mr. Mohit Mathur is a senior advocate and is truly a jack of all trades, as he is a current president of DHCBA, which he won with such margins that it created history in itself. Before being designated as a senior advocate, he used to be associated with the Chambers of Law. He has worked on some of the most interesting and important cases so far and has led the way to make High Court of Delhi more technologically advanced. He's here with us to explain the hardships of being an advocate, especially in these times where technology has seeped its way through in our day-to-day workings. Thank you so much, Mohit sir, for being there with us.
Thank you for calling me.
Let's begin our session. So the first question is, everyone would love to hear the story of a man who made it on his own and made it to the top tier advocates in India. What's your career journey as an advocate?
Prachi, I beg to differ. Nobody makes to any place on his own. Everyone has the support of people around him, his peer, his friends, his family. And I think each of those pillars ultimately helps you in becoming what you are. I was never interested in this field as a professional for choosing this as my career. And probably destiny brought me here. I, along with one of my friends, we were walking across the law faculty after doing our graduation. I did my graduation in mathematics from Stephens, which is a totally diverse subject. And while walking across, we thought, God only knows where we'll go. Let's try this also. And this is when my father was he was a senior advocate in the High Court and a leading criminal lawyer. But nobody had forced me and I didn't show any interest. But as luck would have it, this is where we landed. My father that way was very clear in his mind that if you start with your family's crutches, then you'll be handicapped all along. So you better start working somewhere else, make your beginnings elsewhere so that you can actually make your own grounds. That definitely helped me. I worked with the then Attorney General, Mr. G. Ramaswamy. That chamber actually gave me a lot to learn. One, it taught me the lessons that forget where you come from, forget your origin. You have to stand on your own 2 feet. You have to make a mark yourself by showing your diligence. And one thing which was ingrained in all of us by my peer there, my colleagues in the chamber, and the senior himself, that there is no shortcut to hard work. And we actually got no chance to even scratch our heads. He would pile us with work, and work. So slowly and gradually, and then when he fell ill, he insisted that, again, don't go under anybody's tutelage. In 3 years' time, I've taught you enough. You start on your own. And he supported me. That's why I said nobody does anything on his own. He supported me to such an extent that he passed on a couple of retainers of his clients that at least to start with, you should not be going a begging for work. And you have some work to keep you busy and show your merit. So slowly and gradually, I started working. And over the years, I had some good friends. And as you said, that we had started a firm called the Chambers of Law, which also did not identify with an individual. But like all lawyers always say that we are going to our chamber after the courts. So the name was based on that, the Chambers of Law. So we joined together, joined our hands, started working. And slowly and gradually, my friends kept encouraging me because I was too talkative, always fond of my own voice. So they encouraged me to go and articulate myself in the courts and the matters. And that encouraged and promoted me in my litigation work. And rest, I got the love and affection of all the bar, to which I am always grateful. And I am before you now.
So, sir, you are very famous amongst the youngsters. The generation of young lawyers follows you, listens to you very carefully. Please guide the young lawyers on how to sustain in litigation and what it takes to become a successful lawyer.
One, believe in yourself. That's the first thing. Second, I'd say that your diligence and your sincerity apart, you need a lot of patience and perseverance. Because litigation as such has a very long gestation period. Because you get to perform today, then your next good opportunity or a break, as you would say, may come after 6 months. The opportunity to express yourself, articulate yourself, and actually show to the world that you have arrived comes in absolutely staggered, and there are big spans of time in between. So you need a lot of patience to understand when is your opportunity. And one thing which I keep telling my juniors as well as all the junior lawyers whom I come across is that do a SWOT analysis. Understand your strength and play on your strengths. Understand your weaknesses, try and cover them up. If you can't rectify them, then ensure that they are not exposed. So your chinks are not exposed. And on every opportunity, try and shine. But at the same time, I'd say don't fall to temptations. You'd face the problems. So have patience, persevere with time, and believe in yourself. There is enough room at the top. Nobody can say, it's not like a pyramid where perhaps at the top only one man will be able to stand. I don't believe in it. I feel there is ample room at the top. All you need to do is slowly and gradually make your pedestals, your pyramid. You have your own, each one has his own pyramid. So the foundation should be strong so that as you go up, you have a strong base. And that's based on your perseverance, your hard work, your diligence, your sincerity to law. Marshal your facts, marshal your law, and slowly and gradually go up the ladder. And public dealing. In litigation, public dealing is a very big asset. You must know that you have to be a good listener, which most of the juniors are in such a stressed out environment that they have created around themselves. They need to break that shackles. They have to get out of it. You have enough room, you have enough space, breathe in, breathe out, properly proceed, so that your steps are all sure-footed. I think ज़्यादा ज्ञान मिल जाए.
Nice. So, sir, since you are a senior advocate with a long-standing practice, you must have faced various problems while you were in the profession and while you're going through various cases. What would you say that some of the problems which were recurring in nature, and what have you learned from them?
Prachi, in the litigation side, I'm sure I'm not the only one, but the others also would have faced those problems. Ek to you get initially a little disturbed with adverse orders. When you are young, you take it to heart. You feel that as if the world has just fallen apart. How will I do well tomorrow? Because if this client does not get the order, he'll run away. So that fear it actually starts taking its toll if you do not believe in yourself. As I said, you have to believe in yourself. Benches are sometimes hostile. So, and in my case, since I was veering towards criminal law suddenly had come into limelight, and people started feeling that every man who's coming to the court, every accused, they'd have a prejudice against him. So the benches were hostile, orders were not so forthcoming. So you start feeling those as challenges. And then there are temptations. In litigation, you start feeling somehow to find a shortcut to achieving your goal, because you want to be client driven and you want to be result driven. That's a big challenge. That don't be result driven, because the results are your life's results, which will come later. Every case has its own start and end. Don't judge yourself. Don't identify yourself with a case. You are a professional. Be more objective towards it. Today I might be able to say all this, but you are right. In this journey, even I felt all these things. And I felt that perhaps I might not be able to reach where I was aspiring to be. Only because when you have a spate of adverse orders and you feel everyone is going to run away from you. But then it doesn't happen like that. Life's not like that. And everyone is not always so, I'd say, driven by results. They sometimes see your caliber. If you have done sincerely the work, some clients stick with you. They have confidence in you, sometimes more than you have confidence in yourself. So you've got to not fall to temptations or shortcuts. Continue on your path with diligence. I'm sure each one will go and cross all the hurdles and cross every bridge as it comes, rather than start thinking and planning. I am not too much of a planner, so I don't know how those people who are able to plan for long times can do it. But I am more of a advocate, and I like to go and do things one by one as they come. And to do that, I feel somehow that you must do that to the best of your capability, so that the third party who's watching it objectively will see your diligence, your sincerity to the effort. And that's what sometimes attracts the others to you.
Sir, my next question to you is, like the rest of the world, lawyers have been severely impacted by the unprecedented COVID-19 crisis. What step has Delhi Bar Association, High Court Bar Association taken to help lawyers? And do you have any suggestions for the Bar Council of India?
Prachi, I am fortunate that I have a fantastic team with me. And without mincing words, I can say that each one of them, despite odds, and this pandemic, I think you also are aware, each one faced these problems, either himself or someone in the family was down with this COVID, and the strain on the family health, your curtailment of your movement, all those things created a mess. And the second wave was just, it took its toll on every individual. Everyone in the neighborhood, everyone next door, every family was impacted. Fortunately, our team worked as a very, very cohesive unit. Somehow, the president always gets the kudos and accolades, but it's actually the team which worked hard. And they have some very, very ingenious ideas which came from them. And since each one had his own sphere of contacts, they pooled the resources very well. We were able to launch ex gratia scheme last year, as well as an ex gratia financial assistance scheme this year. And this year we have decided to go on till the time this pandemic is over. So it's a rolling scheme. It's not ended. People who have been impacted earlier had already availed of the benefits. Whatever little we can do, we can't obviously change the course of your life or your change the destiny. But whatever assistance, whatever help we can do, we try to do from that. We initially got the testing facilities made available to our members in the High Court. Thereafter, while the second wave was on, we tried to get the whatever medical and paramedical help and made available to people whomsoever we could. Few of our executive committee members were organizing delivery of cooked meals, because those who were in distress or were not able to, if the entire family is down with COVID, how do you make the meals? Or if the lady of the house is down with COVID, the people, senior citizens, they were in difficulty. So some of our colleagues and executive committee members, they organized the free meals to be delivered at doorsteps. And one thing I can proudly say is that we have not divulged the names of anyone who has been given any kind of benefit from the Bar Association to at any place whatsoever, to keep their confidentiality, their integrity intact, so that they don't feel, Prachi, that they have been in any manner, they should not feel compromised about their things. Now with the vaccination there, we started vaccination camps. And earlier we were trying to get the vaccination of our members done through the High Court dispensary. Thereafter, with the assistance of our members and some senior members of the bar who contributed to the pandemic relief fund, which we started, we were able to start vaccination drives, through which we were able to vaccinate nearly about 3,800 to 4,000 people in those drives in the span of about 2 months. And now it's continuously going on with the High Court dispensary. We are working in unison with them to get there. At least some of them are still, the second shots are remaining, those who are not received. We got the staff members also of the lawyer staff, our own High Court bar staff, the clerks, their families. It was open to everyone. So if everyone can be vaccinated and secured, that makes the life as much easier. And to return to normalcy, it would help. So with that aim in mind, we tried to do all these activities. And we are still in the continuous process of helping out our members in whatever manner we could. In fact, in the High Court, the sanitization, the cleaning, the drive of getting all the chamber blocks cleaned, sanitized, placing all these sanitizers, making them available at regular places after each distance, some distance, so that people feel confident in stepping out and coming to the court. So I'm lucky with a good team. I'm able to do whatever little I can do for my members. And allow also in the first leg of the pandemic, I am slightly technologically challenged, but the other members of my team who were understanding the technology better, they were able to coordinate with the courts, the High Court and the IT department of the High Court, to have the video conferencing facilities of the hearings started, making them available, and to make it easier for those, some of whom are not able to afford the facilities, or some of whom who do not have the facilities available. We have our own areas in the bar where we have made the VC facilities available with internet and all, so that people can do their work at least there. So this is whatever
So,
little I could do.
So I would like to thank you and your team for making so much effort during this tough times. It has helped a lot of people I know. So thank you so much.
Not at all.
So talking about the new digital age of litigation. So how do you think the artificial intelligence and legal technology in legal research can help lawyers to work more efficiently and minimize their workload?
I doubt whether the workload can ever be minimized, because with the increasing work, the workload will never minimize, and I don't want it to minimize also, because the more the work, the better it is for my fraternity. But you're right, the artificial intelligence and technological advances will have their inroads in the legal arena also, especially in where we had to shuffle through pages and pages of books, and from one book to the other to find what is the relevant one. You people can do it on the click of a button. And those who are good in the computer and working on these platforms and apps or whatever you have, and especially with the judgments and the research material being made available through the computers, definitely the access to them is faster. But having said that, I still would say, see, no artificial intelligence works on its own. We don't have a robotic life. When you come to for justice, access to justice cannot be robotized. And reason for that is there is a human element. That human element comes from humans only. Artificial intelligence will be depending on the feedback by the humans who feed that intelligence into that artificial intelligence. But when you have to compile it, when you have to present it, when you have to articulate it, and sometimes develop it, because ultimately everything is not straitjacketed. When you have to develop it, at that point of time, it's the lawyer and the human in you that alone can do the work. And law is dynamic. Every day we keep changing the law. Every day the law keeps developing. And with the technological advances, service by WhatsApp was not an accepted norm earlier. That serving the opposite side within WhatsApp before this pandemic was neither anyone you would speak about it, nor was it an accepted thing. But somehow over the pandemic, and necessity is the mother of invention. So with the situation coming like this, today in courts, in virtual hearings, we'd say, my lord, we did it. We sent him by WhatsApp and he was informed by WhatsApp. We have sent the status reports in WhatsApp, the counter by WhatsApp, emails are being sent. And judges also alike, they have to also adjust to the technology. So yes, I'd say it's made the task easier, especially with the growing volume, it has made it easier. But if you feel that workload is going to minimize, I doubt it. I seriously doubt it, because we are so litigation friendly people, that at the drop of a hat, we want to file a litigation. So with the work turnover increasing, technologies may keep on advancing unless and until you have only made it more comfortable. So today, I don't need to go through muck and mud or dirt to find out the law. I can sit in an air-conditioned room and with two people along with me, use two computers more, and then on. So
like just to mention that notice being served via WhatsApp, what are the other areas that have changed due to the new digital age in litigation process?
see, I would say technology keeps changing the whole scenario every now and then. E-courts were a concept. Today, we have seen it as a reality. it's transformed the initially e-filing or this electronic filing in PDF formats was limited to a few jurisdictions, which were more commercial, etc. Today, this is happening in all jurisdictions. I won't say it is a 100% successful thing, because certain jurisdictions require some paper to be seen. It may require something physical to be seen, not always this scanned and formatted files. But yes, technology has changed the whole landscape, because now the judges also have 2 computers with them rather than 60 files. And many of them who are adept at the technology are using the same computer, partitioning the screens. The screen has one part has the paper books on it. The other part, they have the video conferencing going on. Now, summons by emails, communications by emails are becoming slowly and gradually being creeping in as acceptable norms. The fact that WhatsApp, whatever its limitations as far as its security things are concerned, but for the mundane services and mundane transfers of documents, which don't have any kind of a confidential aspect to it, are being accepted. And slowly, the once the society is accepting it, we are not alien people. We are also from the same society. Judges also are coming from the same place. Those are the same newspapers we read, the same jokes we crack. So everyone, and WhatsApp University is now growing for everyone. So the things are changing. The electronic form of service, electronic form of transfer of documents, which used to be doubted. And then earlier people would say, okay, bhai, I have not been served, though he was served by electronic mail. And he would say, sir, I didn't check. Today, nobody says that, because you are opening your computer every few hours. If not, it's not switched on all the time. It's at least opened few hours, because most of the transfer, because you're not meeting physically. So there's no question of people coming in contact. So as I said, service of summons, now even government departments are being told. And fortunately with this, in some of the hearings I saw, few of the judges even said, we are just passing it over. You take instructions on WhatsApp. So forget transfer of documents or taking adjournments. This kind of technological acceptance is even expediting the hearings. It's not getting adjourned for the mere asking. That you don't have to ask, all right, come by 1:30 or 2:30, just before I get up, you bring the thing on WhatsApp. That's good enough. And sometimes they'd say, all right, just mute yourself and you seek the instructions. So these are now being taken in as an accepted norm. The norms are changing. The rules of the game will change.
So we see many litigants and advocates are really enjoying the virtual proceedings. However, this cannot be implemented on a permanent basis. What is your view on the virtual hearing becoming a permanent option for a hearing before the court?
It's a very contentious issue in my High Court bar. And I've already taken a stand as based on what the executive has resolved, and we have communicated as the sentiments of the bar after we did a survey amongst the lawyers. See, this has eased the access to justice during a turmoil, during a pandemic, some disturbed times. This cannot take the norm, and not for one reason, but for several. I somehow feel it can be a good substitute and an assistant to the physical hearings. That in case there is a difficulty, in case there is an urgency, in case there is a situation where the physical court is not available, or physically the counsel is not able to come, or somebody who wants to access the court is not able to reach the court physically. For those exceptional cases, it can work. Probably in certain jurisdictions like arbitrations, or where there is a document which is the main thing, there maybe this can continue, but this cannot operate as the total substitute. Reason being, you've seen it, the pendency and backlog of cases has piled up during this last 1 year, 1.5 years. And reason is the whatever efforts the judges may have put in, but they are not able to finish and wind up their work with just this VC, video conferencing, because we have only been able to handle 2020 and 2021. Even they have not been fully disposed of. We have not been able to touch the backlog. What was pending on the date when the lockdowns came in March 2020, those cases have not been touched at all as yet. For the first time now, from Monday onwards, 2019 cases will be there. So before 2019, things are still lying there, waiting for the judges to pick up those files. And you have to appreciate, it's only 10% of the lawyers who have 50% of the work. And they will still have the work, even if you remove the old cases out of the reckoning for the hearings. But what about the remaining people? Those people who have 2 cases or 3 cases in a month in the High Court. And what about evidence? Can you have evidence recorded without the witness coming to the court? How will you rule out any kind of a pressure in the recording of the witness? The testimonies, can you rule out the coercions? Can you rule out whether, when I am asking a question, how do you rule out now with your phone on your side and only up to our torso we are able to see on the screen? He may be prompted by his counsel what to answer. Then the most important part in the recording of evidence is the demeanor of witness, which the judge notices. Then technical glitches. Those glitches can be actually naturally occurring, or it can be created also. So these things cannot take away the relevance of physical hearing. Our founding fathers were not fools when they said that there's an open court system. The hearings have to be in the court where the presiding by the judge gives a semblance of authority, a decorum, a somberness there. The solemnity of being in the court and performing the work is totally different than if I am sitting with my shirt and a band and my black coat, but I'm not even bothered about my full dress. My robes are not there. I may be in my sneakers, or for all you know, in my slippers. So see, that solemnity that is attached to the court hearings also has some meaning. So I feel you can keep it as a good assistant for your physical hearings. And mind you, it is not only that this pandemic, this thing happened, but in our High Court, in fact, in some cases, the court allowed people to give their version by way of video conferencing long back. So yes, for exigencies, please continue it by all means. And places where, like I remember in certain appeals which used to be lengthy, the judges used to ask the lawyers by consent, Why don't we do it on a Saturday? So that we utilize a Saturday. What do? So you utilize that Saturday, both the councils would come, it would not disturb the entire system. Similarly, use this platform for those places where the judge and the parties are ready to deal with it on the virtual platform, because it doesn't disturb either the system or the daily working. But in district courts, in rural areas, where you are not getting the electricity, where is the question of virtual thing? Wi-Fi kahan se aayega? So let's not see ourselves in that elitist category. Let's talk about a common man, and lawyers also are amongst the common people by and large. The chunk of lawyers are amongst that category. There are few and scattered few who are in that HNI category and the elitist. Let them not feel that they have a sense of entitlement for everything. Let's consider ourselves more grounded. What does a common lawyer, common man of our fraternity need? And going by that, we should proceed. At least I, as the representative of those people, I would continue to advocate that only.
Sir, I completely agree with you. So, sir, how was your experience adjusting to this digital mode of litigation?
Oh, pretty tough initially, because barring a WhatsApp video call, I had no idea, except once or twice when I had to do some kind of this video conferencing with some foreign clients, that my juniors had set it up for me. But for the first time, when this was being thought of and we were discussing it, when we had the High Court had to be closed for this pandemic, initial 2, 3, 4 days, there was exchange of ideas amongst judges, the IT cell of the High Court functioning, and they had to first convince us also as members of the bar, the representatives of the bar, that this can work, this can function. So before the platform was developed, we were told this is possible, and demonstrations of that took place. We saw the demonstration, then we went back home. Then the couple of judges who were kind enough to work with us, they would educate us we would keep the video conference, this WhatsApp call on, and the computer also on simultaneously to show them, sir, now tell us, what is it that the next thing we have to do? Then they guided us, in fact, took our finger and took us around for everything, and then showed us how it worked. Then we would continue the message. And then personally, I would say I was lucky. My juniors were there to help, my children were there to help me, because we are learning technology from your generation, not from I am personally not, I am slightly still technologically challenged. So, but yeah, waded through it and probably survived it.
So, what would you like to suggest? Any further changes in the virtual hearings?
See, the mode of virtual hearing, I would hardly be the right person, because I don't know the technology so much. I am okay with whatever it is. The more you can improve it, like now we have learned how to share documents on the screen, how to transmit certain documents while we are still doing the hearing. We are able to use the computer to its optimum thing by multitasking. But the difficulty where I find is that only the new cases are digitized. The old documents, old things are still not digitized. And then this technology is not available with everyone. a man who has to work on a mobile to do his hearing, because ultimately the utilities like electricity and etc. will be provided only by the agencies, the authorities. It's not in our hands. So what happens when during the hearing the electricity goes? Some judges are kind enough to wait for you so that you are able to connect from a separate device, or some have been really indulgent with lawyers that they have even allowed them, they have opened their own mobiles and called them up and said, all right, you argue, I will keep it on a speaker so that everybody else can hear you. But those are far and few. Just the biggest drawback of this VC hearing is the reduced number of cases which are handled. Because of the technology, because people have to, the judges, the lawyers, everybody, to reconcile your physical file or your document with your screen, it's time consuming. And we are not able to handle the workload so much. So the difficulty is, again, if we continue to persist with the technology and technology alone, we are actually harming the system, because the old cases are still lying in dust, gathering dust. And lawyers in general are not able to basically work. Abhi, you know it, that the limitation periods have been put to a halt. Now, simpliciter A versus B cases have not been filed, where it's not a question of an urgent relief. If there was urgent relief, they came up. But those which are not requiring an urgent relief would not come up before the court. Now tell me, with those simple cases which will be filed in the district courts and in the high court, how many of them can you take up with your technology? You will not be able to do it, and those poor people will suffer. So we can't, India may have progressed, but India is still a country which has a vast majority not having all these resources. So to keep that in mind.
Sir, coming to the end of the session, my last question to you is, what's your advice to the law students who are looking to join litigation?
First thing, don't look at Mr. K.K. Venugopal all the time. Look at people who are just 2 years your senior. Where have they gone? Look at people who are 5 years your senior. Where have they reached? Look at people who are 10 years your senior. Where have they reached? Because if you look at achievable targets and achievable icons, then rather than those icons of Mr. Rodgi, Mr. Dave, Mr. Harish Salve, Mr. Venugopal, then what will happen is you'll get frustrated very soon, because litigation, as I said, has a long gestation period. So look at your peer, work hard, which I'm sure your teachers and all would have already bogged you down with all that bhashan and the gyan. So first thing is, believe in yourself. If you like a thing, then do it. Because if you don't like it, you will never be able to do it well. Take it from me, unless your heart is there, your head will not work. Because litigation requires thinking on your feet. So you have to leave a lot of scope for thinking on your feet. And thinking on your feet, you can do only when your heart is in the right place. Another thing that you need to understand is that in justice delivery system on litigation side, you're not going to have a walk in the park. So be ready for hostile questions. Be ready for adverse orders. Be ready for hostile opposition. And be ready for being scoffed at, sneered, laughed, commented. Make yourself thick-skinned for that. but be sensitive to the needs of your client. Understand that and then proceed. See, first think about it. Should I do it? If you decide that yes, I should do it, then make it in your mind just absolutely firm and crystal clear that I will do it. Then only you will achieve and success rate of even 20, 30, but 40% is more than enough. No lawyer on earth can claim that he's got a 100% result. Because 100% result lawyers have not reached the top. So they would have had only 10 cases and they would have won those 10 cases and that's it. Those who are doing a lot of work, take it as a given. It's an accepted thing that they will get some relief, they will get some not. You win some, you lose some. Don't lose your heart. Believe in yourself. And also, don't prejudge your case. That's one thing law students have a problem because they come with that theoretical knowledge, that theoretical mindset, and they say, tuck, 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 tuck. This is done. This is the law. I know the law. You don't know a damn. Just forget what you have learned in law schools and what they don't teach you in law schools, start learning that. And that is how to advocate, your art of advocacy, how to push your point and push it to what limit. Sometimes you win really gone cases and sometimes you lose really good cases, but that's part of the game. It's just a wrong day, an off day, when you may not win that case which you thought was good. And it's not merely your brilliance every time that you may win a lost case. It may be that lucky day when you have a good judge. So take it in the spirit of the game and be ready for it's the journey that matters, as they always say, not the results. Enjoy the journey, enjoy your every day. And litigation walas, though, you must enjoy the canteen, the cafeteria, the gossip, and everything at all of it. So don't get bogged down and don't get bogged down with the bhashans that you keep receiving day in and day out. Just collect yourself, keep yourself composed, and jump. That's what I would say.
Thank you so much, sir. This was quite an insightful and engaging session. Your words were really, really encouraging. So thank you so much for your time, sir.
Most welcome, Prachi. Thank you.
Thank you so much. Anything you would like to add?
I'd say those listening to me, I'd request all good students to come into litigation. I'm a propagator of an advocate for lawyers and law students joining the profession as litigation counsels. Reason is, this is where the law develops. This is where you make the law. You are participating in that historic journey of developing the law. What you miss out, you may be earning and adding to your purses in sitting in comfortable homes, in comfortable places, as law officers, as corporate lawyers, following the law. Only reading what that lawyer who was in litigation, reading what he has done. But as far as the law itself is concerned, you will be a party, a participant to the development of it. Nobody remembers the solicitors who filed Keshwananda Bharati, but people remember the counsels who argued it. Even today, they said the argument, because the judges note the argument of the counsel who argued it. Nobody writes in the judgment that the pleadings were very beautifully drafted by so-and-so. It was ably argued and assisted by so and so. So please, in the profession, in the litigation side, so that you can actually contribute to the development of law. We have the first-hand knowledge of it, the first-hand experience in it. That's what I always implore all the young law students, that join in here. Oh yes, the money definitely is lesser here initially, but it will go higher when you go higher. Thank you.
Thank you so much, sir. Thank you so much for your time and thank you so much for your words and your